It is now the time and place for counsel for each side to present their closing arguments or summations of the evidence. Counsel for the state will have the opening summation. Counsel for the defendant will then have an opportunity for reply. And since he will only address you once, he will also present his summation. Counsel for the state will then have his closing summation to the argument of the defendant. The counsel for each party will be summarizing the testimony that you have heard and the evidence which has been presented during the trial. They will merely be recalling the evidence as you will later. They will not intentionally try to mislead you. And if their recollection of the testimony is not the same as yours, you must follow and rely on your own recollection. The summations of counsel are merely that, summations. They are not evidence, nor should they be construed by you as evidence or instructions on the law. The summations are intended to help you in understanding the contentions of each side. You should give them your close attention. Mr. Smith?
Thank you, Your Honor. May it please the court, counsel. She's 18. We're cuddling in a boat. First things out of the defendant's mouth. After two officers picked him up at his house and brought him back to answer questions about a matter he had no idea about. He's then informed that there have been allegations made by Kayla Smith. She was 18. And we were just cuddling in a boat. I don't know, maybe she's misunderstood. That's what the defendant wants you to believe. There's a misunderstanding that's accidental. This is really simple, ladies and gentlemen. The instructions are your guide, and they tell you how to get ultimately to where you should go. And in this case, it's a guilty verdict. Instruction number 14, 3 elements. Element number 3, defendant and Kayla Smith are not then living together as husband and wife. Obvious. Element number 2, defendant performed a sex act with Kayla Smith when Kayla Smith was 14 or 15, and either of the following. Kayla Smith was related to defendant by blood or affinity to the 4th degree. There's no contest. Absolutely. It's her uncle. Defendant is 4 more years older than Kayla Smith. Nobody's contesting this issue. The 2 remaining issues. Between May 1, 2005 and April 30, 2006, did the defendant, on one occasion, not 2, not 5, not 10, not 15, on one occasion between that time frame, perform a sex act with Kayla Smith? Not against her permission, with Kayla Smith. And there's no requirement that it be by force because 14 and 15-year-olds can't give consent. That's why the statute's written the way that it is. One time. You heard testimony from the victim, Kayla Smith. She can't recall the day. She can't recall the exact month. She can give you a season. In her mind, she picks out softball season. Well, Kayla, how can you be so sure that it wasn't softball season of your freshman year, your sophomore year? She only played softball for 1 year. The summer between her 8th grade year and her freshman year, when Kayla Smith was 15, is when she recalls it beginning. When it began. Not when it ended, when it began, one time. She testified with certainty that it happened at least 10 to 15 times in that first year when she was 15. State only has to prove that it happened one time, just once, for you to return a guilty verdict. Instruction 15 tells you, the jury, what a sex act is. And the sex act described by Kayla Smith, sex act defined by these instructions by the law, between the finger or hand of one person and the genitalia of the other. It's exactly what she described happening 10 to 15 times between May 2005 and May of 2006, or June 2005. At least 10 to 15 times. Other acts, other instances. The instructions, as you heard, aren't used to prove, or cannot be used to prove, outside the window of when Kayla was 15. They can be used to rebut defendant's contention that I thought of her as my own daughter. I never had any sexual desire for her, but she was like a daughter to me. One of the first things that comes out of his mouth when he's being interviewed by law enforcement is he reverts back to an incident that happened 7 to 6 years prior in a boat. Of all the hundreds of times these families have gotten together, of all the many occasions where they've done things together, in 2014 when he was interviewed, Kayla made an allegation. He goes back 7 years and describes the very thing that Kayla describes, except for he leaves one thing out. Intent. He doesn't even deny that it could have happened. He said it was an accident. It could have been an accident. She misconstrued it. We were snuggling. We were trying to maintain warmth. It's exactly what she said. It's exactly what he told law enforcement, but he left that part out. And he also told law enforcement that, on a couch, it could have been when we were playing this game. Who knows? You were asked by law enforcement, did you inappropriately touch your niece? You know the answer should be no, I did not. That's ridiculous. You watch the video, he doesn't deny it right out. He gives you every reason in the world to think that it could have been an accident. Not accidentally just rubbed up against her. Oh, I can see how she probably misconstrued that situation. Everything Kayla's telling you, minus one thing, and that's the sex act, an intentional sex act. That's the evidence. The state had 2 witnesses. We discussed in jury selection, conflicting testimony. Well, obviously there's conflicting testimony. We discussed physical evidence. There is none. It's not required. The instructions don't require physical evidence by the state. How many sex assaults have an eyewitness? Well, I guess the ones where the victims live, they do. But how many third parties view sex assaults? They don't. It rarely happens. The instructions state at least 2 places to use your common sense and experiences that you have in your life to determine credibility and to reconcile any conflicts in testimony. What's reasonable to believe in this case? And that's what you're going to go back and you're going to do. Instructions are there. State's made its case. It's not beyond all doubt. It's beyond all reasonable doubt. Beyond a reasonable doubt. You don't have to prove with 100% certainty that this happened. Beyond a reasonable doubt. Thank you.
Thank you, Mr. Smith.